Welcome to Probate Weekly. I'm your host, Bill Gross. Bill Gross at Bill Gross Probate on social media. We do this every week to talk about different practices on how to be better in serving our customers, whether a real estate agent or an attorney or vendor in the space, working with real estate and succession, whether it's planned ahead with an estate plan or not with probate, or in some cases, North Carolina one can be passed over without planning and yet avoiding probate. We're excited to have here today partner in a law firm based in North Carolina from McGuire Wood and Bissett. We have Andrew Atherton. Andrew, thank you for joining us today.
Thanks, Bill, for having me on.
And so one of the things we talked about when we started in North Carolina is that you don't need probate to transfer property in North Carolina in many cases. Talk a little bit about why that is.
So yeah, North Carolina is unique in the sense that real property, so your house or land that you may own that's in North Carolina, the North Carolina real estate law says that when someone dies, that land or house passes automatically at the time of death to the named heirs under a will, or if there's not a will, to the intestate or the North Carolina state written will succession plan. And so that is different than I think in a lot of states in which you've got to go through a process in which the court authorizes the transfer of that property to the named people in the will. It frees us to not, particularly because the house ends up being, or land ends up being most people's largest asset, frees us to not always look at revocable trust as a way to provide probate avoidance, because we can, their biggest asset doesn't go through the probate administration process anyway.
Though when I think about the probate cases I deal with, I can imagine you have cases where there's fights over who is a spouse, who's not a spouse, who's a child, who's not a child, other side agreements, last minute deeds. So I imagine there still probably is a vigorous probate litigation business in North Carolina as a result of that.
Oh, absolutely. And, it doesn't mean just because it passes by to the heirs under intestate succession, it doesn't mean that people shouldn't have a good plan in place. I would always encourage people to visit a lawyer and understand and know what their plan is, and likely everybody should document that in at minimum a will. But in a lot of cases, it does end up being some sort of revocable trust. So if you have land that's owned by a business like an LLC or other sort of corporate entity, that does go through probate. It has to require the administration process. So we, in the vast majority of cases, use trust as a way to own that LLC prior to death, so we can avoid the estate administration process.
One of the questions came up in a case I dealt with recently. I was surprised to find that an LLC owned by a trust, that they could transfer that by selling the LLC. Therefore, even though the self-property might require court approval, in this case in California, I know the laws changed by state, that didn't require court approval because they weren't selling the property, they're selling the LLC. So I'm sure there's different layers of risk and different layers of opportunities and nesting and then who gets the assets. That's why you probably have to have a plan in place to get the result you really want at the end rather than getting close.
Correct. Right. And it's good that's why, we start planning as an estate planner by sending out a client questionnaire and asking about, extensive details about what assets are out there. It's because it's not one size fits all for folks. And it takes us, any sort of planner, knowing really the details of what assets you have, how they're held, whose names are on them, in order for us to help shape kind of what kind of documents or plan you need.
One of the biggest challenges for estate planners that I deal with, particularly in California, is that often, or not for the planners, but for the customers, is that the plan never got funded, meaning they met with the attorney, they signed the book, they signed all the documents, that all the property is going to be in this estate plan, but they don't actually deed the property from Bob and Mary to the Bob and Mary Trust. Is that an issue as well in North Carolina? And how do you resolve that? Or is that just you missed the boat?
Yeah, so as long as you can do that funding pre-death, then you're okay. But you're exactly right in that it's not just enough to take the step of creating the documents.
Right.
Have to go through the process of either funding assets in the trust or directing changing beneficiary designations and such so that assets pass to the trust or pass to heirs directly.
Right.
That's the reason that we again get a lot of asset information, and a big part of what we do is help folks sort of walk through that funding process on the back end.
Yeah.
In fact, we've had conversations as a practice group. We've got about 26 lawyers in our firm, and about 12 of us do planning and probate administration or estate administration work. And so a big part of our firm does that. And we've actually talked about potentially hiring like a paralegal or someone to literally just work to help folks fund their estate plan, because it's so important. That step, when skipped, really means that a lot of the documents still may work the way you want them to, but a lot of the goals of the documents get missed.
Right. Like if they have multiple siblings or children, and they want to disinherit one, for example, in the trust they do that, or reduce their inheritance substantially. But if they don't execute the estate, then the property is decided, at least in North Carolina, by the standard distribution. So I imagine each of the children get an equal amount, and that might not be the intention at the time. Maybe the decedent gave extra money to one of the children ahead of time and wanted to make things equal. Who knows? But
right.
Unfortunately, the law is not going to anticipate all those details, and your good work of doing the plan goes down the drain. So you talk about maybe getting a paralegal. The other one is following up with the customer, right? Because you send them home with a nice book, and you give them a list of things to do. And if they don't do that, now do you handle the deeding of the property yourself, the funding of or is that something you assign to the customer, or do you have a vendor that you refer them to?
No, we have a real estate lawyer, actually 2 real estate lawyers in our firm that do deeds for us. And so particularly when it's real estate, we'll assist with preparing the deeds to make that happen. We'll, at the moment, we'll reach out to, if we have contact information for like their investment advisor or banker, then we'll reach out and give them some funding instructions. And at the moment, we have left it to then the client to follow up and finalize that funding instruction. Besides executing a deed, we've done all that stuff and recorded it, but we've left it to the client to do the final follow-up with their advisor. That's where we're having conversations. Do we need to bring somebody on so that they're not paying lawyer rates to hound or encourage people to keep working through their funding process?
Yeah, that's a challenge. At some point, you stop being an attorney, you become kind of like somebody's mother.
Right.
You didn't send the documentation, get back to me. You didn't get the property deed over. And at some point, it's on one hand, you want it done to get the customer the result they wanted, the client. On the other hand, you want to make sure you wear your lawyer hat and not your mother hat. So that can be a challenge. So the other issue seems to come up from time to time is the storage of the documents. I've had numerous customers who passed where there was a trust, and we know it was because the property was funded into a trust. but whoever, at that point, successor trustee or second successor trustee or third can't find a copy of it, and now we're out of luck. So what's the law in North Carolina regarding property's been deeded into a trust, but you don't have a copy of it in order to determine who has authority or what's supposed to be done with it?
Yeah, so we have the Uniform Trust Code, and that gives us some flexibility if we have a copy or can find a copy. Even an unexecuted copy can sometimes be utilized as evidence that that's what the intent was with regard to the document.
Mm-hmm.
And so, if there was not a executed copy that can be found, then it would require some sort of process of going to the court and getting a judge to agree or sign off that document is the document that was executed. That can be complicated and expensive and take a fair amount of time. So we try to avoid that. One of the ways that our firm has worked to avoid that is we actually offer for clients. We are lucky enough. We're actually in a historic building in downtown Asheville that was formerly a couple of different banks, and so we have the both blessing and curse of having vaults all over our building, and so we store original documents for individuals with that are clients of ours, and we keep those in fireproof safes and old bank vaults, and we find that it's the best way to make sure that we can locate an original when someone passes away.
My father was an attorney, and growing up, he had a small firm, and one of his partners did wills and trusts. And in their law office building, they bought a small office building, and they built basically a vault. As a little kid, I used to go in there and see all the originals, and it seemed like that was the standard practice for attorneys. And I think reading history about famous people who were attorneys like Abraham Lincoln and John Adams, that was common. They stored documents for customers. Of course, not as sophisticated as vaults, but whatever they had. But it seemed like that stopped happening as the course of business, at least in California. Maybe there was liability issues or they couldn't find them. And so it seemed like it changed at one point to a period of where attorneys didn't want to keep the forms. And then now it seems like with online, there's other ones who either keep originals and or keep online copies of it. Do you as well? Now, I'm really impressed to hear you guys keep the original. I think that's fantastic that as a service to the customer, because the original is always better than a copy. Do you also offer digital services, and how do you integrate that into your practice?
Yeah, I mean, all of our documents that are executed through us, we scan into our cloud portal, and we store those for individuals, and we keep a copy, in our system. The ability we do, I can say that our litigation attorney is that does our trust and estate litigation work. Every time we discuss vault storage, she tells us how terrible of a decision from a liability standpoint that is. So
right.
She doesn't love the fact that we store those documents, but just from a perspective of lawyers, but we just think it's such a good client service to do that. I know, it's a struggle. I think we are set up in a sense that because we have, a number of lawyers and have been around, our firm just celebrated its 130th anniversary this last year.
Wow.
And have been around so long that we feel like we're aligned to be able to store documents on a continuing basis. I've seen definitely, I think if I was a private practitioner, I'm not sure I would want to necessarily store documents. the law requires us to, if we're shutting down our office or have retired or pass away, those documents have to find its way back to a home. And that can be an arduous task if it's a individual practice, for sure.
Yeah, no, I think one of the real advantages of a larger firm, you have the leverage that and offer an additional service. I think that your customers can't. And to me, it seems valuable to have it. It's funny that your attorney tells you about the liability. As a real estate agent, I always say, the attorneys will always tell you why not to do something, and if you take all their advice, you'll never do anything. You'll sit at home in a fetal position because that's the best way to avoid any liability. But the question is, where is there fair risk return? And I think keeping the original documents for your customer, at least you're making the effort to try to serve them. I think that's always, to me, the North Star. What serves the customer, and you do your best you can in that area. So you probably along the way also see customers who come to you, or clients who come to you with problems from estate plans done by other firms. Do you guys handle administration and or litigation of plans that are developed outside? And if so, I guess that's the first question. Do you handle those kinds of plans?
Yeah, we do. And
just notice, for those watching, just notice the frustration in his voice there, the tonality, because he's really saying, I don't want to, but we have to because we want to be good service. But I could feel that, the pain.
We do have a trust and estate litigation attorney, and she does a lot of advice regarding rights under prior documents. I say that in that I hope that our litigation attorney is working on things that we haven't drafted as planners. That's always the scare, the worry as a planner is that you've done something. Right. But we do, in North Carolina, because we do have the Uniform Trust Code, we've got a lot of flexibility on adjusting estate plans. And the way I describe it is that we can almost do estate planning for people after they've passed away, in the sense that if the documents or the plan doesn't necessarily match up to what we can clearly tell was the deceased person's wishes, our law provides an extraordinary amount of flexibility to work to try to adjust a plan on that. Wow. It uses, we can do things like decanting trust, which is essentially taking an old trust that had some maybe language in it that was built in maybe the 1930s even, or 1940s, 1950s, and creating a trust that has language that's more modern and refreshed and has a better outlook as to the way our law works today. And there's a big amount of flexibility in doing that, and she does a fair amount of that work. We do a fair amount of work in sort of helping families find a way through disagreements and arguments about how things were set up. I say it that way in that, everybody thinks of the litigation attorney as the one that goes in with guns blazing, but honestly, a good litigation attorney is going to try to get people to the point in which they can come to an agreement as to making things work out in the way in which the deceased wanted things to happen.
Well, or another way to put it, I think, is a great litigation attorney or anything gets the customer what they want as best as they can. Right. And oftentimes you can't get the customer in litigation because it's not to anybody but the judge at the end of the day. But do the best you can to get them what they want. And sometimes the best way to do that is by, resolving matters, negotiating matters, mediating matters. And sometimes it's gun blazing. And I'm sure you also see customers. There's some who just, if I can just, shoot guns nonstop and spend every dollar I have. I hate my brother or sister, whatever, so much. I don't care. And there are attorneys who will do that. And there are attorneys who won't do that. So that's giving the customer what they want, unfortunately, I think in some cases.
Yeah. And, we try to avoid good lawyers are gonna make sure that their client has reasonable expectations as to what
Yes.
happens, because you can spend tens of thousands of dollars when you end up in a courtroom, and so trying to avoid that is at all costs is.
So what would you say are one or two of the most common mistakes you see in estate plans that end up getting litigated? Like one or two maybe preventable things or errors made that could be caught, but weren't, and therefore it leads to litigation.
So I do a lot of special needs planning. I do a lot of helping folks understand and work out plans to take care of um, disabled adults. And we do a fair amount of modification, and maybe it's not even necessarily disputes, but we do a fair amount of modification of documents or trust after someone's died, because things are going outright to an individual that may be receiving a whole litany of government benefits that would be affected by receiving an inheritance. And this isn't like folks receiving $10 million and all of a sudden they're off Medicaid. That's maybe not as big of a deal as someone that's receiving $200,000 and all of a sudden they're off Medicaid. If healthcare becomes something they have to pay for privately, that money will go extremely fast. And so we do, we see a fair number of folks that haven't thought that through. Either one, because they've done planning on their own, either by pulling forms online or whatnot, or they've gone to a lawyer that may not do this as a full-time job. They may go to a lawyer that does have their real estate closing attorney do their will,
Right.
which may or may not, lead to the result in which they're asking all the questions and the lawyer's not necessarily asking all the questions to get the documents correct.
I would say it's not a problem until it's a problem, and I think that a bad, at least in California, a bad estate plan that at least gets the property out of probate is better than none, 90% of the time. But then that 10%, if you're in the 10%, it's bad. So so it all depends on your circumstances. I think the more particular circumstances, the more you need to be thinking about these things ahead of time. And obviously, children and even adults, special needs, medical situations, these are all things that require care. Otherwise, you end up blowing through hundreds of thousands of dollars that you didn't need to for some reason. So that's a common. So if I would say to you, and if you were, I'm sure you're too modest to answer the question on a live podcast, but if it was just me and you on the phone, I said, I'm just curious, why would you think that you guys stand out as an estate planning, service compared to the competition? I mean, I know I tracked you online a little bit and saw you, and I was impressed. But if you were to say, what were one or two things that maybe you feel like you distinguish as a firm, as an offering to a client or prospective client over the competition, or that you aspire to, what would you say that is?
So, I mean, I think, the lawyers in our firm, we have all committed to focusing on our specific practice area, whether that's estate planning, elder law work, corporate real estate, even to the extent of probate. We have a couple of lawyers that do most of our administration type work. And because we have committed to focusing our practice and working together as teams and getting other lawyers involved if there's a corporate interest involved, then we have really learned our craft well and have an in-depth knowledge of, trust and estate planning, and don't feel like that I don't feel like I have to be everything to a client. I have to know where concerns may jump out, and by being able to focus our craft, I think that helps in being a subject matter expert. I mean, we want our lawyers to be those subject matter experts. And then I think I do a lot of, I mean, I'll say I and then the rest of our lawyers do a lot of work with our state bar association on in working with attorneys across the state in doing things like drafting legislation and other items that keep us on the edge of what's happening in the legal realm.
Now, I know you're in Western North Carolina. Do you practice throughout the state? Is it kind of practice that you can do statewide, or is it very limited to certain jurisdictions?
Primarily, it's limited to Western North Carolina. Western North Carolina square footage is a pretty large area, and because a large part of our side of North Carolina is rural, we do a lot of work. I mean, Asheville is the biggest city in probably a couple 100-mile radius, and so, well, you know, west of Charlotte, then we do a fair amount of work for folks all across the western part of the state, mostly.
Got it.
I have random clients across other parts of the state, but mostly because we've connected with their connection through Western North.
And so, from a business point of view, I would imagine that you must get business referred by attorneys, just like you say that you're going to handle Western North Carolina. You know, attorneys in Durham or Greensboro or even Charlotte, I would think, that aren't familiar with the particular practices of your jurisdictions. I know in California, the laws are statewide, but each county has their own rules and procedures, and I think also style and feeling, and they're completely different. So is that a good chunk of your business is coming from attorneys in other parts of the state?
A huge portion of our business comes from attorney referrals, both attorney referrals across the state. Honestly, I think a fair amount of attorney referrals locally. I think getting colleague referrals is like the best form of flattery, and it's why it's important to us to be a part of like these statewide groups. Even though it's maybe a 4-hour drive to Raleigh to work with the legislature, we do it because it's important connection wise and important sort of to stay involved and provide good client service.
I know, having grown up watching Mayberry RFD, driving to Raleigh is a big deal. So
it is driving to Raleigh. Still, from Western North Carolina, it feels like that time. And
so I bet it does.
Andy was taken off to.
So a lot of people on my platform are real estate agents, and at least in California, and one of the things I try to also evangelize is that real estate agents should be involved in, because we see how people take property or hold title of property, whether they have a plan in place or not. We see that. Good time to get one if you're buying a property, good time if you're selling a property, to evaluate those questions. Do you work with real estate agents much? And if so, what's that look like in your practice?
Yeah, I have a huge connection to real estate. They're great support services, both, we do a fair amount of trust and estate administration ourselves. So that involves buying and selling real estate at times, with us being the sellers or buyers. And so we work with real estate agents in that way. And I think just having good connections and bouncing ideas off of each other and what's going on in the real estate market is really important. I'm personally involved with the strategic planning group that we get together once a month, and it's about 3 real estate agents, a individual that does this mortgage broker that does a lot of reverse mortgages for seniors, and a couple of different folks that provide like both financial advising services and senior type caregiving or transition type services. A couple of EXP brokers too.
How about that? Those are the good ones. Just FYI, if you're wondering. So, one of the challenges of real estate agents is they when they want to get the probate business, they think, oh, I should just call every attorney and ask them for referrals, not understanding that the business that they're asking you to refer is what finances your fees and also is critical to your customers. It's a very intimate relationship, I think, that's not most commonly going to be secured by just a cold call. And I also know that many realtors present themselves as experts in probate and really haven't done the work. It's easier to buy a certificate and put up a fancy website, but to actually do the work. So what do you look for? You must get phone calls from realtors your customers want to work with, or that, have a property, they need a real estate agent to sell. And obviously, the customer has a say, you have a say. What do you look for in a real estate agent to determine whether or not this is an agent you want to work with, both in terms of just on the customer you have in front of you and or maybe even future referral business?
I think ones that are, willing to ask questions and get that they don't necessarily know everything. I'd rather a real estate agent be willing to say, hey, I'm seeing this on a deed and I'm not totally understanding what this means. Can you help me make sure that I'm writing the contract correctly? More than if someone just tries to quickly put a contract together and hopes that it's all right. And then we have to go back and fix it or make, changes to it. I'd rather somebody ask the question up front and, be willing to issue spot capable of saying, hey, I think there's a problem here, and be willing to ask the question. I think that's helpful. We do a lot of, in our working, we hold ourselves out with real estate agents and financial advisors, accountants, where we offer, look, if you've got a problem, even if it doesn't end up with a referral to us, we're happy to answer one-off questions for you if you just ran up with an issue.
In California, we have really two tracks of real estate sales and probate. 9%, I would call standard. There's maybe a notice of proposed action gets filed with the court, but publicly, but basically, it otherwise looks like a regular transaction with a form that protects the estate. And then about 10% need court approval, where they literally there's a process. You have to advertise a certain way, bring it to court. Court reviews it in detail, and they require a lot more sophistication. And in California, we're really blessed. We have, I think, very great forms that cover all those circumstances that I can attach to a listing or to a purchase that protect me as the agent, protect my client. And I'm amazed to find out that no other state has anything like that. So I guess my question is, you must in North Carolina have occasionally properties that you list that aren't standard but need a court process. And so what do you do to protect your client? Do you have a template that you give your clients, or is there a certain wording you put in that's sufficient, or is it just California is so much more litigious, and in North Carolina you're all friendly people, nobody sues each other? Like what do you advise your clients?
Definitely litigation.
I would think you're a litigation attorney, so I would think.
So we oftentimes court approvals required for cases in which there's an incapacitated adult or an individual, or minors associated with that. And so that requires a court approval process. And we actually don't have forms for the court approval process. A lot of the reason is that it most of the time really needs a lawyer to help shepherd that approval through the court system. And so, what we typically advise is either getting that lawyer involved prior to putting the house on the market for sale, if possible. That's the preferential treatment. Or sometimes realtors come forward and have gotten an offer, hopefully haven't signed the contract yet, because if we've got an offer, then we can put some language on the standard offer forms that the realtors use to state that it's going to require court approval in the process, and essentially subject the contract to sell on court approval. And we've done that in the past. We have run into situations in which the contract was already signed, and then it was later determined that there was court approval required. In fact, I was recently purchased a house as trustee of a trust that we're administering, and the seller was selling on behalf of an incompetent adult, and I had suspicion that it was happening like that, but the contract wasn't written to indicate that. And so I went on and agreed to the contract as a buyer, to later find out that they didn't have authority to sell until the court approved it. Knowing the process that they had to go through and then I was willing to kind of wait because I wanted the house for my beneficiary, but you could certainly run up to a scenario in which the buyer is not so happy about the situation.
And so then as a real estate agent, I might contact you and say, hey, I'm working with the client. They're your client as well. We'll list the property. And I imagine you have certain verbiage. So we'll just list it. We'll mention the court may be required. And then when we get an offer, I'll come to you and you'll provide some sort of a template or some sort of a form that you want to attach to.
Walk through the process of getting the court approval for the sale.
And so what fascinates me, you can imagine, I guess in California, we have standard listing form for probate and standard offer form for probate as well. And as a listing agent, when I list a property, I can copy some of that verbiage and put it in my MLS. But really, everywhere else in the country, it's just one attorney writing a memo or an email or a form at a time. I just find it fascinating. Is it just because it's just not common enough to standardize, or it seems like an advantage to you that if you've already done it and you know what to do, and over time you've learned this verbiage works, this verbiage doesn't work, so you amend it over time. I imagine that this is part of what people pay for you as an expert.
As an expert, and I don't know. We have a agency, or part of an agency called Administrative Offices of the Court in North Carolina, and they write a whole lot of probate forms as like standard probate forms in order for someone to work to administer an estate on their own if they want to. But that's never been a document that they've created as a form process. They may feel like there's too many quirks or too many differences between one situation in which you're asking for a court approval to sell or not. But remember, the vast majority of our real estate after someone dies does not require court oversight for sale anyway.
At all. Yeah. Yeah. That's a big difference. It's a big difference. And so if you have a smaller amount, just at some point, of course, California is a huge state. And so, everything that's small becomes big at scale. And, as far as I know, anybody who's listening to this podcast, I believe California is the only state where realtors have preset forms for probate, conservatorships, guardianships, and North State has that set form. But I think what Andrew's laid out here is this is a great way to show your interest in doing business is call the attorney and say, hey, this is where it's probably headed. Do you agree? And if you do, what's your process? Do you provide some verbiage for the contract? And so that way it's not a surprise, but something you plan on ahead, and also it'd be a good dialogue starter to do some business with you. So
it would be a good starter, and it shows that the real estate, agent is focused on helping troubleshoot and make sure that the sale goes smoothly,
right.
Instead of just trying to move on to the next client or the next contract. And it really sort of makes you stand out as like doing your due diligence.
One of the, again, because I do business at scale, there's things that come up that are probably more rare for some practitioners. But one thing that commonly is there's a property that's going to be transferred or being litigated, but there's no liquid assets, and the inheritor, the beneficiary, needs money for hiring an attorney, paying for fees, and so on. And so I'm really involved in two different procedures. One is advances to heirs, which is expensive money, kind of like a factoring, where they're not going to see the money till the end of the probate, but they get a portion of it ahead of time. Or loans to administrators, which are more like a business loan, expensive, but not, like a factor. Are you involved? Does your firm get involved with either of those services? Or do you help customers who come to you without money up front, or do you need somebody to write a check and be able to finance the process?
So, we don't typically, we have not in the past utilized those services or offered sort of advanced loans or any of those things as part of a piece. Typically, we're looking for folks, especially if we're dealing with an estate in which the only asset's real estate, and we think we're going to have to get court approval on a sale. We may ask for money up front in order to make sure that we're covered fee-wise in order to help someone walk through that. Unfortunately, it can just be a time-consuming process, and we've at times been burned on trying to wait on that to happen.
For sure. So you're in Western North Carolina. The only thing that I've heard of late of Western North Carolina is the devastation from the hurricanes last year. How has that happened in your area, particularly Asheville, and how has that affected your business?
So downtown Asheville was, did fairly, didn't have huge problems with Helene. We, all of our county suffered significant issue and damage to our water supply system,
Wow.
which meant that for downtown, we had little water for weeks, about 4 weeks, and once the system was restored, the water was brown and undrinkable for another 3 or 4 weeks. So we went from like September 27th when Helene hit to right around Thanksgiving until our water system was in which you could actually drink the water.
Wow.
And so that's been pretty devastating. We've got a huge, we're fairly large tourist town, and so downtown restaurants, businesses, those sort of folks got hit pretty hard. Some of the other things that hit us really pretty difficult was the fact that we are a tourist town, and the hurricane hit right at the top of our busy season, which is sort of the leaf season, fall, leaves turning, and it becomes a, beautiful hues of orange and yellow and red all around us in the mountains. But, there are a lot of us that are kind of our blessings that we've come across and fared fairly well, because there are big swaths of our particularly sort of eastern side of the county and areas around us that got hit really hard.
Yeah.
The mountains that had always been our refuge served as sort of a funnel for all of the water. We had about 2 days worth of rain before the hurricane hit, and the mountains just funneled all of the water into the valleys where people lived, and so those outlying areas just got flooded, and the little creek in your backyard turned into a raging river, and it hit those, but hit a lot of folks around us really hard. Downtown didn't get the destruction damage, but is still struggling. We need people coming back and enjoying our area because our small businesses are still teetering a little bit.
Well, one way to solve that is to do business with a law firm that specializes in estate planning in Asheville. Andrew, I really appreciate your time today. I know we covered a lot of things, and I'm kind of coming up on the time here. So, and your hourly rate, I can't keep extra. I'm just teasing.
Oh no, you're fine.
I do appreciate it so much. But our guest is Andrew Atherton, who's an attorney in Asheville, North Carolina, which is Western North Carolina, and you can get his contact information on the screen, and we'll have it in our description notes as well. And he's an attorney with McGuire, Wood, and Bissett in Asheville, North Carolina, and they do business and can help throughout that Western North Carolina area. Thank you so much for your time today, Andrew. It's really a pleasure meeting you, and look forward to continuing to work with you.
Absolutely. It was great to meet you too, Bill, and great. Love what you're doing and getting information out there.
Thanks so much. And for the rest of you, this is Probate Weekly. We get together every week and talk about probate information, how we can better serve our clients, whether an attorney, realtor in the space, or vendor. And you can continue the conversation with a Facebook group, Probate Weekly, as well. Go there with questions or to referrals. You're looking for referrals, have referrals. I'd love to have you do that, whether it be a realtor, estate agent, or attorney, or vendor. I'm Bill Gross, at Bill Gross Probate on social media, and contact information below. Do you like this episode? Let me know. If you don't, let me know what you'd like to talk about, what you should talk about. If I can help anyway, please reach out. And as always, make today your best day ever. Thanks so much.